afternoon, and welcome once again to Troutman Pepper's Patents Post-Grant podcast. My name is Maia Harris, and I'm joined today by two colleagues who I'm hoping need no further introduction because we've spoken with them before. Dustin Weeks, a partner in the IP group out of Atlanta, and Megan O'Gara in the Health Science IP group out of Rochester. Dustin and Megan, thank you as always for joining me.
Happy to be here.
Pleasure as always, Maya.
Our topic today is a big one, reissues, and we could easily turn this into a lecture, I think, on all things reissue procedure related. But what I really want to focus on, if we could, is an element of reissue law and practice that I personally found incredibly confusing, and that's recapturing subject matter. What does that mean in the context of reissues, and how does this all play out in practice? So maybe just to set this up a little bit, Megan, why might a patent owner think about a reissue? When is the time to do that? Is there a right or wrong way to kind of even think about this process from the beginning?
Sure. I'll start us off from the very beginning here, where we're talking about reissues. This is a statutorily based procedure at the Patent Office. It gives patent owners a way to go back to the Patent Office and correct a whole host of errors, perfecting priority, amending inventorship, correcting inventorship, correcting errors in your spec. But top of the list, which we're going to talk about today, is amending the claims. So you can do that on the basis of claiming more than you had a right to claim during original prosecution. That means you're going to go back in with narrowing amendments, and you can do that really at any time during the term of the patent. And then claiming less than you had a right to claim. And that's really what we're going to focus on today, is claiming less than you had a right to claim. You're going to go back to the Patent Office, and you're going to ask for broader claims. You're going to do that by amending the original patent claims or by introducing new, broader claims into the reissue application. And that comes with limits. So it comes with limits in time and scope. And the limit in time is that you have to do it within 2 years of issuance. So by that 2-year anniversary date of your patent issuing, you have to go back and say you're going to broaden your patent. You have to say it in very clear terms when you file the application that you're broadening your claims. And then it comes with a limit in scope. So the broadening amendments or those broader claims cannot recapture subject matter that was surrendered during original prosecution. And that is really a very loaded phrase.
And it's absolutely where I wanted to focus today, really. So what does that mean? Surrendered in original prosecution. I mean, on some level, this is the essence of my confusion, because if you're asking for a broader claim, you're essentially capturing something that you had not during prosecution. But what is this limitation on recapturing all about, Dustin?
Yeah, sure. And it is somewhat of a confusing issue. So we generally think about recapture as applying this 3-step analysis. We're looking at what are the we're determining whether and in what respect the reissue claims are broader than the original patent claims. So, claim construction is always at issue because you're looking at what are the scope of my current claims, or what are the claims that I'm trying to get broader, and what are the scope of my previous claims. And then you're looking at, in what aspects were those broader features were they surrendered. And when I say surrendered, I mean, so let's say, for example, I had an original claim where I said, it was a device comprising A, B, and C. And then during prosecution, I amend the limitation A. So I say that, it's the device now comprises A, B, and C, wherein A is A prime. Well, I've now surrendered some portion of the scope of the claims where I went from A to requiring A prime. So basically what that means is that the recapture doctrine would preclude me from then going back later in a reissue application and trying to recapture that subject matter that was only A and that it didn't require A prime. Did I explain that clearly?
Yeah, I mean, can we throw some examples out there? And I always laugh about this because Megan uses the peanut butter and jelly sandwich analogy, which I think is actually really helpful. Megan, can you walk us through your classic example?
Yeah,
it's lunchtime, so.
Yeah. So let's say like your prior art, when we're analyzing this, your prior art that you faced during original prosecution, you were claiming a sandwich, and you were claiming a peanut butter sandwich, and the prior art actually had a peanut butter sandwich in it. So to avoid that prior art, you said, oh, okay, well, my current embodiment that I'm really interested in is a peanut butter and strawberry. I like strawberry jelly. So a peanut butter and strawberry jelly sandwich. So I'm going to amend my claims to require strawberry jelly in addition to peanut butter. And then you get your claims issued and you're coming up to the 2-year mark and you're like, oh, darn. So everybody out there has these grape jelly peanut butter and grape jelly sandwiches. And I don't think I needed strawberry at all. I could have just claimed jelly. I'm going to go back and I'm going to reissue my claims and try and delete strawberry from my claims. And when you go through Dustin's analysis that he just aptly pointed out, so the aspect that's been broadened relates to the jelly. That is the aspect that was actually surrendered during original prosecution because we added strawberry jelly to overcome the peanut butter sandwich prior art. And then you have to ask yourself whether or not the surrendered subject matter, and now I'm getting to the third step, which I'm sure Dustin was going to get to, is whether the surrendered subject matter has crept back into the reissue claim. And this is really the meat of where, you might have a showdown with the examiner during prosecution of a reissue application, because if you are broadening an aspect that there is a question about whether or not you've surrendered, you can actually avoid the rule against recapture if you've modified the limitation that you added during original prosecution, but you haven't eliminated it. You can't completely eliminate it. You can't completely eliminate A prime. You can't completely eliminate strawberry jelly, but I'm going to argue I can eliminate strawberry. I've modified it, but I haven't eliminated it. And as long as it avoids the prior art of original prosecution, you actually avoid the rule against recapture.
Right. So for clarification then, so what you're saying is if you attempt to broaden your claim to cover jelly, peanut butter and jelly specifically, without limiting it to strawberry, and thereby cover grape jelly, assuming that you're not running into prior art, then although you are broadening it, you're not necessarily recapturing the limitation that was surrendered in prosecution.
That's right. And the prior art of original prosecution serves as a ceiling to what the surrender encompasses.
Right. And that seems to me to be where this gets very tricky and somewhat gray is what exactly, where are the metes and bounds of that recapture? So in the jelly context, that sounds simple enough, but I think in practical terms, I suspect that it's a lot more complicated.
Yeah, I think it's really never that simple. This is the subject of a lot of examiner interviews and a lot of applicants, I think, trying to frame up what the aspect that was surrendered really was. You might have a number of different features that relate to a similar aspect of the claims, and you're going to argue a modification of that aspect as you've defined it during prosecution. And the examiner will probably define it more narrowly than you have. And that's where you, during prosecution at least, Dustin probably has a better perspective on litigation, but during prosecution at least, that's where you really have it out on recapture.
So that's an interesting question because you did raise the concept of litigation. Are these recapture issues also, kind of vetted during district court litigation? Is this something we're going to see not just in the reissue prosecution, but later on in litigation as well?
Yeah, absolutely. If you think about it, if there's an actual recapture issue, or at least, a defendant in a lawsuit believes there's a recapture issue, they're not just going to waive that issue and say, oh, well, I guess the examiner, already decided there's no recapture issue. It's similar to any patent infringement case where you're making an invalidity argument based on 102 or 103. Presumably an examiner has already said, no, there's no anticipation issue here. There's no obviousness issue here. But, the reality is sometimes the examiners get it wrong. And, it's rare, but they do get it wrong. And then I see that particularly in situations where, and we haven't really discussed this yet, but, you can surrender subject matter not just because you amended the claim, but based on particular arguments that you made during prosecution. So while an examiner may take a look at the prosecution history of the original parent and say, oh, there's no amendments made, therefore I don't really have to worry about reissue. It's unlikely that an examiner is going to or is going to have the time to go through a pretty thorough claim construction of what the claims look like after original prosecution, and then to compare that to what are the claims that the applicant is now trying to get in reissue. And in a patent infringement action, of course we do that, right? You have a lot more time to come up with these arguments. So you find issues of recapture in a litigation that you just, the examiner, if they weren't really before the examiner never really considered that specific issue.
So you're thinking about this. You're thinking about this during the course of claim construction, not just as an invalidity argument during district court litigation. Right. Is what you're saying.
Yeah. Well, I mean, if you look at it, the way you have to analyze the recapture issue, it all comes down to what do the claims cover? Do they, what did they cover in the original patent? And that's going to be based, of course, on all intrinsic evidence, which is going to be both amendments to the claims and arguments made over the prior art. And now I'm going to have to look at, okay, well, what are my new claims, my reissue claims? And what do they cover? Now, do they cover things that are broader than the original claims? And in what aspects are they? So, one thing that you may be doing in litigation is thinking about your claim construction in a way that if you win, maybe it provides you a better recapture argument down the road.
So going back to the jelly analysis, it strikes me that there's a lot of different ways to make a peanut butter sandwich with something sweet that might not include recapture or involve a recapture argument. So, we were talking about this before. So if the amendment that you're seeking is no longer limited to jelly, I mean, what happens when you want to start kind of broadening out even further, like to jam or to apple butter or to bananas or some other sweetener that's with your peanut butter and jelly sandwich, leaving aside the prior art issue, of course? Is that going to implicate any of these recapture issues or broadening issues, or is that something completely separate?
I think it definitely implicates recapture. I think at that point, it comes down to the argument of modified but not eliminated. So it depends on whether or not the examiner, at least in prosecution, whether or not the examiner would accept the premise that jam is like jelly or jam is a modification of jelly. Or are you trying to define the feature, more broadly, like you say, like is it a sweetener? Or is it a sweet component, and then you've modified it but not eliminated it? So it depends on that, on that argument and how you make that argument. Of course, not in the context of jam or jelly. I mean, these things are really complicated. So it's much, it sounds simple in that context, but really it's all more complicated when you're in prosecution with your claims, definitely. But it depends. It depends on the argument you have there.
And I suppose it also depends on what's in the specification, right? So, I mean, if what you're doing is bringing in a totally new embodiment, strikes me that you're going to be pursuing a different, as the patent owner, perhaps pursuing a different strategy if you've decided suddenly that you want your second embodiment that had nothing to do with your first set of claims involved in some further prosecution after reissue.
Yeah, and I think that at that point, maybe you take the jelly, right? Like you'll take your jelly and reissue your first case, and then you can file a continuing reissue application. So you can continue to prosecute broader claims after the 2-year, as long as you've met the 2-year time limit for the first reissue application, the first broadening reissue application, you can continue to broaden your claims in subsequent applications. What you might be talking about, there are other, reissue is so complex. There's so many things to talk about, but there are ways to avoid recapture totally. If you have an embodiment in your application, like you're talking about, that's not a peanut butter sandwich at all. Like it is something that's been overlooked. It is a feature that you've described as part of your invention, but you never had a claim to it. You can actually avoid the recapture analysis altogether. It becomes an overlooked aspect. You've never claimed it, so you've never surrendered it. And that is a wholly sort of separate way to sidestep recapture.
And is that something that can be done in reissue, or is that something that's done in reissue continuation practice?
Either. Okay. Yeah, it can be something that you go in with, and maybe it's a part of your original claim set, and you avoid recapture because it is an entirely separate, overlooked aspect of your specification.
And I think this is one of the things that blows my mind, kind of to your point, Megan. This is a complicated procedure, but this is one of the things that blows my mind because, oftentimes I think we look at these patents, especially patents that have, we think, completed prosecution, and think of the claim set as static. And in fact, that might not be the best way for any of us to be looking at these claims and patents as a whole, even after the conclusion of prosecution.
I think that's right. I think at the end of the day, patent owners will receive, from prosecution counsel, those letters that tell you that 2 years is approaching from issuance of your patent, and you should think about whether or not you want a broadening reissue. And I think maybe those are glossed over sometimes, but really you should take a long look at your current product, your current commercial product. You should take a long look at the original patent and do a health check and figure out if there's something that needs correction and whether you should do that within the 2 years, and maybe present a broadening claim just to be sure that your iron is in the fire on a broadening reissue should you need it in the future. It's really important to take a look at that, balancing, of course, an analysis of recapture before you go and file that case, and an analysis of, the duty of disclosure reattaching to you once you open a reissue application, and all of that against maybe what your business needs are.
And that, of course, is a totally different podcast for us to consider at some future date, which is what is the can of worms that you're opening if you decide to go down that road. But Megan, I mean, just as you're talking, it actually strikes me that there's, kind of additional things that we should be thinking about if we aren't necessarily patent owners, but maybe are individuals or entities thinking about things in terms of an FTO position. Strikes me that we need to be thinking about things in the future, not just as closed prosecution in that context too. What do you think, Dustin?
Yeah, I mean, I completely agree. You see a lot of FTO opinions from various counsel where there's a search for relevant patents that comes up, and then you go through typically the claims of those patents, and you kind of you just reject a patent as soon as you find a reason where the broadest claim of that patent is not going to read on let's say a particular product that I'm launching. But a lot of times we may see a patent that it's closed, but let's say the broad independent claim includes one limitation that we're missing, but arguably maybe that limitation wouldn't be required for patentability, or maybe I see that limitation come in and during prosecution, but the specification of the patent would support broader claims that may read on my product. Well, oftentimes you'll just see that patent is dismissed. It's, we don't infringe the independent claim, we're good, but it's still within 2 years, right? So what I've actually started doing a lot of times is advising my clients on those, particular patents, especially for products that are, FTO is a real issue or a real risk for the client. Let's come up with a list of those patents that maybe we need to monitor, just to, especially for that 2 year period, at least, to see if any type of broadening reissue is filed.
Really great conversation, both of you. I want to wrap it up and give you an opportunity to kind of give me a couple takeaways and give our listeners a couple takeaways from today's discussion. What do you think?
Don't ignore that letter from prosecution counsel. I think take a hard look at those cases that you don't have family members pending in anymore, and you're coming up on that 2 year mark as a patent owner, and take a long hard look at the health of those patents and whether or not there's an opportunity at the 2 year mark.
Yeah, I would echo that, and I might add this. If you think about from the time you develop a product and the life cycle of that product, let's say I develop a product at day one, and I file a provisional application immediately, and maybe it takes a year to launch that product. And at that point, I'm filing a non-provisional, and maybe 3 or 4 years after that, I'm finally getting a patent that's issuing. Well, and then my 2 year period starts. Well, that product may undergo a lot of evolution during that 5 to 6 year period. And, be sure before that 2 year period, well before that 2 year period, I'm really evaluating, I'm looking at my claims and I'm trying to decide, do I need to file that broadening reissue? Are my original claims that I got 3, 4, or 5 years ago, or that I started pursuing 3, 4, 5 years ago, are those still reading on what my commercial product is and, those of my competitors?
As with everything else in patent law, nothing is black and white and nothing is static. So thank you, Dustin. Thank you, Megan. Thank you to our listeners. We invite you to join us for our next installment of this podcast series, the name of which I will not repeat right now, in which we discuss strategy, trends, and other happenings at the PTAB. Our next episode will take us back to the land of IPRs, and we'll be discussing sovereign immunity at the PTAB. Troutman Pepper's intellectual property team helps clients develop and implement global protection and commercialization strategies for intellectual property assets in virtually all industry areas. For more info about how we can help you, visit the intellectual property section of Troutman.com. You can also subscribe and listen to our other Troutman Pepper podcasts wherever you listen to them, including Apple, Google, and Spotify. Thank you again, Dustin. Thank you, Megan.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.